On the constitutionality of RA 9522 or the Philippine Baseline Law, it is constitutional. Baseline laws are nothing but statutory mechanisms for UN Clause 3 states parties to delimit with precision the extent of their maritime zones and continental shelves. UN Clause 3 and its ancillary baselines laws play no role in acquisition, enlargement, or diminution of territory. Under traditional international law, typology, states acquire or conversely lose territory through occupation, accretion, cession, and prescription, not by executing multilateral treaties on the regulations of sea use rights or enacting statutes to comply with the treaty's term to delimit maritime zones and continental shelves. GR 187167, August 16, 2011, Professor Merlin Magalona et al. Versus Honorable Eduardo Ermita. Maritime zone, territorial sea, extent, 12 nautical miles from the baseline, rights exercise of sovereignty. Contiguous zone, 24 nautical miles from the baseline, rights, jurisdiction to enforce customs, fiscal, immigration, and sanitation laws. Exclusive economic zone, extent 200 nautical miles from the baseline, rights, right to exploit the living and non-living resources. On the question whether Section 23 or the plea bargaining of RA 9165 being unconstitutional, it is unconstitutional. The power to promulgate rules of pleading, practice, and procedure is now the Supreme Court's exclusive domain and no longer shared with the executive and legislative departments. Salvador Estepona Jr. versus Honorable Frank Lobrigo, GR 226679, August 15, 2017. What is doctrine of operative fact? The doctrine recognizes the existence of the law or executive act prior to the determination of its unconstitutionality as an operative fact that produces consequences that cannot always be erased, ignored, or disregarded. It provides an exception to the general rule that a void or unconstitutional law produces no effect. It nullifies the void law or executive act but sustains its effects. Arroyo versus President Aquino, GR 209287. Under legislative department, whether Senate investigation of a case already pending in court violates the sub judice rule, it does not. A legislative investigation in aid of legislation and court proceedings has different purposes. Ongoing judicial proceedings do not preclude congressional hearings in aid of legislation, and the court has no authority to prohibit a Senate committee from requiring persons to appear and testify before it in connection with an inquiry in aid of legislation in accordance with its duly published rules of procedure. Romeo II et al. Versus Estrada, GR 174105. How about the Priority Development Assistance Fund, or PDAF? Is it unconstitutional or constitutional? It is unconstitutional. The defining feature of all forms of congressional pork barrel would be the authority of legislators to participate in the post-enactment phases of project implementation. Legislators cannot exercise powers which they do not have, whether through formal measures written into the law or informal practices institutionalized in government agencies. Else, the executive department be deprived of what the Constitution has vested as its own. Belgica versus Honorable Executive Secretary Ochoa Jr., GR 208566. Under the executive department, can the pardoning power of the President be limited by legislative action? No. The exercise of the pardoning power is discretionary in the President and may not be interfered with by Congress or the court except only when it exceeds the limit provided for by the Constitution. The only instances in which the President may not extend pardon remain to be in 1. Impeachment cases, 2. Cases that have not yet resulted in a final conviction, and 3. Cases involving violations of election laws, rules, and regulations in which there was no favorable recommendation coming from the COMELEC. Thus, when the former President Estrada was granted absolute pardon by former President Arroyo, he was fully restored with all of his civil and political rights, including the right to seek public elective office. Attorney Alicia Rizos Vidal versus Comelec, GR 206666. Going back to the constitutional limitations on the suspension of the privilege of the writ of habeas corpus and declaration of marital law. Grounds for declaration: invasion or rebellion when public safety requires it. Duration: not more than 60 days, following which it shall be lifted unless extended by Congress upon the initiative of the President. Note that the Congress, if not in session, shall within 24 hours following such proclamation or suspension convene in accordance with its rules without any need of call. Another, the initial declaration of marital law and or suspension of the writ of habeas corpus is determined solely by the President, while the extension of the declaration and or suspension, although initiated by the President, is approved by Congress. And it is the duty of the President to report to Congress within 48 hours personally or in writing. Authority of Congress to revoke or extend the effectivity of proclamation by majority vote of all its members voting jointly. Take note that the framers of the Constitution only settled the manner of voting by the Congress, that is, voting jointly, by a vote of at least a majority of all its members, in order to revoke the President's proclamation of martial law and or suspension of the privilege of the writ of habeas corpus. But they did not directly take up and specify that the voting shall be done during a joint session of both houses of the Congress. Alexander Padilla et al. Versus Congress of the Philippines et al. DR 23167 and 231,694. While it is the authority of the Supreme Court to inquire into the sufficiency of the factual basis for such action, at the instance of any citizen, decision must be promulgated 30 days from its filing. Article 7, Section 18, Paragraph 3. What is the effect of declaration of martial law? State of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or legislative assemblies, nor authorize the conferment of jurisdiction in military courts and agencies over civilians where civil courts are able to function, nor automatically suspend the privilege of the writ. What is the application of the suspension of the privilege of the writ? It applies only to persons judicially charged for rebellion or offenses inherent in or directly connected with invasion. Note that during the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days, otherwise he shall be released. The framers of the 1987 Constitution not only placed the President's proclamation of martial law or suspension of the privilege of the writ of habeas corpus within the ambit of judicial review, it also relaxed the rule on standing by allowing any citizen to question before the Supreme Court the sufficiency of the factual basis of such proclamation or suspension. The third paragraph of Section 18, Article 7, veritably conferred upon any citizen a demandable right to challenge the sufficiency of the factual basis of said proclamation or suspension. It further designated this court as the reviewing tribunal to examine, in an appropriate proceeding, the sufficiency of the factual basis and to render its decision thereon within a limited period of 30 days from the date of filing. Representative Edsel Lagman et al. Versus Honorable Salvador Medialdia et al. GR numbers 231658, 231771, and 231774. 2017. The phrase in an appropriate proceeding appearing on the third paragraph of Section 18, Article 7 refers to any action initiated by a citizen for the purpose of questioning the sufficiency of the factual basis of the exercise of the chief executive's emergency powers. It could be denominated as a complaint, a petition, or a matter to be resolved by the Supreme Court. Same case. Under the Judicial Department, under the 1987 Constitution, judicial power includes the duty of the courts of justice not only to settle actual controversies involving rights which are legally demandable and enforceable, but also to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. The present Constitution has expanded the concept of judicial power, which up to then was confined to its traditional ambit of settling actual controversies involving rights that were legally demandable and enforceable. Samahan ng mga Progresibong Kabataan or SPARC versus Quezon City, TR 225442, August 8, 2017. How about Section 14, Paragraph 1 and Paragraph 2 of RA number 6770 or the Ombudsman Act of 1989? Section 14, Paragraph 1 of RA 6770 or the Ombudsman Act of 1989 is ineffective until adopted by the Supreme Court. Paragraph 2 is unconstitutional. Section 14 reads, Restrictions. No writ of injunction shall be issued by any court to delay an investigation being conducted by the Ombudsman under this Act, unless there is a prima facie evidence that the subject matter of the investigation is outside the jurisdiction of the office of the Ombudsman. No court shall hear any appeal or application for remedy against the decision of findings of the Ombudsman except the Supreme Court on pure question of law. The first paragraph took away from the courts their power to issue a TRO and or WPI to enjoin an investigation conducted by the Ombudsman, and encroached upon the Supreme Court's constitutional rulemaking authority. Thus, pending deliberation on whether or not to adopt the same, the court, under its sole prerogative and authority over all matters of procedure, deems it proper to declare as ineffective the prohibition until it is adopted as part of the rules of procedure through an administrative circular duly issued therefor. On the other hand, since the second paragraph limits the remedy against decision or findings of the Ombudsman to a Rule 45 appeal and thus attempts to effectively increase the Supreme Court's appellate jurisdiction without its advice and concurrence, it is therefore unconstitutional and invalid. Curfew Morales v. Court of Appeals, TR 217126 to 27, November 10, 2015. On the issue of allowing Marcos burial at the libingan ng mga bayani involves a truly political question which is within the full discretion, authority, and wisdom of the President Duterte to decide? Yes, it involves a truly political question. President Duterte did not gravely abuse his discretion when he allowed Marcos burial at the libingan ng mga bayani because it was already shown that the latter is qualified as a Medal of Valor awardee, a war veteran, and a retired military personnel, and not disqualified due to dishonorable separation or reversion or discharge from service or conviction by final judgment of an offense involving moral turpitude. If grave abuse is not established, the court will not substitute its judgment for that of the official concerned and decide a matter which, by its nature or by law, is the latter alone to decide. Saturnino Ocampo et al. Versus Rear Admiral Ernesto C. Enriquez et al. TRs 225973, 225984, 226097, August 8, 2017. What is the remedy in adding another member in the Judicial and Bar Council, JBC, or to increase the representative of Congress to the JBC? The remedy is not judicial but constitutional amendment. While it is true that Section 8 Number 1, Article 8 of the 1987 Constitution did not explicitly state that the JBC shall be composed of 7 members. However, the same is implied in the enumeration of who will be the members thereof. And though it is unnecessary for the JBC composition to be an odd number, as no tiebreaker is needed in the preparation of a shortlist, since judicial nominees are not decided by a yes or no vote, still, JBC's membership cannot be increased from 7 to 8, for it will be a clear violation of the aforesaid constitutional provision. Representative Reynaldo O'Malley versus JBC, GR 228628. On whether JBC's policy of requiring applicants for judgeship in the regional trial courts to have served at least 5 years of service as judge of first-level courts constitutional or unconstitutional. It is constitutional. The policy does not violate the Equal Protection Clause. Substantial distinctions do exist between lower court judges with 5-year experience and those with less than 5 years of experience, and the classification enshrined in the policy is reasonable and relevant to its legitimate purpose of selecting those with proven competence. Villanueva versus Judicial and Bar Council, GR 211833. Whether clustering of nominees for every vacancy by the JBC is unconstitutional or constitutional, it is unconstitutional. The power to recommend of the JBC cannot be used to restrict or limit the President's power to appoint, as the latter's prerogative to choose someone he or she considers worth appointing to the vacancy in the judiciary is still paramount. The JBC, in sorting the qualified nominees into 6 clusters, 1 for every vacancy, could influence the appointment process beyond its constitutional mandate of recommending qualified nominees to the President. Clustering impinges upon the President's power of appointment as well as restricts the chances for appointment of the qualified nominees. Honorable Philip Aguinaldo et al. Versus President Benigno Simeon Aquino. Does Section 5 of Article 8 limit the court's quo warranto jurisdiction only to certain public officials, or that excludes impeachable officials therefrom? No, it does not. Quo warranto and impeachment are 2 distinct proceedings, although both may result in the ouster of a public officer. Strictly speaking, quo warranto grants the relief of ouster, while impeachment affords removal. A quo warranto proceeding is the proper legal remedy to determine a person's right or title to a public office and to oust the holder from its enjoyment. It is the proper action to inquire into a public officer's eligibility or the validity of his appointment. Under Rule 66 of the Rules of Court, a quo warranto proceeding involves a judicial determination of the right to the use or exercise of the office. Impeachment, on the other hand, is a political process undertaken by the legislature to determine whether the public officer committed any of the impeachable offenses, namely culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. It does not ascertain the officer's eligibility for appointment, of election, or challenge the legality of his assumption of office. Conviction for any of the impeachable offenses shall result in the removal of the impeachable official from office. In this case, the OSG's quo warranto petition challenged respondent's right and title to the position of Chief Justice. He averred that in failing to regularly disclose her assets, liabilities, and net worth as a member of the career service prior to her appointment as an Associate Justice of the Court, respondent could not be said to possess the requirement of proven integrity demanded of every aspiring member of the judiciary. The OSG thus prayed that respondent's appointment as a Chief Justice be declared void. Clearly, the OSG questioned the respondent's eligibility for appointment as Chief Justice and sought to invalidate such appointment. The OSG's petition therefore, is one for quo warranto over which the court exercises original jurisdiction. Republic versus Maria Lourdes Sereno, GR 237420. Under constitutional law powers of the state, is the valuation of property in eminent domain essentially a judicial function which cannot be vested in administrative agencies? Yes. The executive department or the legislature may make the initial determination, but when a party claims a violation of the guarantee in the Bill of Rights that private property may not be taken for public use without just compensation, no statute, decree, or executive order can mandate that its own determination shall prevail over the court's findings. Much less can the courts be precluded from looking into the justness of the decreed compensation. Land Bank of the Philippines versus Eugenio de la Uta, GR 190004, August 8, 2017, citing EPSA versus July 149, SCRA 305. Why is the imposition of the Quezon City governments of socialized housing tax constitutional, while that of garbage fee is unconstitutional? The levy of socialized housing tax is primarily in the exercise of the police power for the general welfare of the entire city. It is greatly imbued with public interest. On the other hand, the ordinance imposing garbage fee violates the Equal Protection Clause and the provision of the Local Government Code that an ordinance must be equitable and based as far as practicable on the taxpayer's ability to pay and not be unjust, excessive, oppressive, and confiscatory. Jose Ferrer versus City Mayor Herbert Bautista. Bill of Rights. Does the writ of amparo covers extralegal killings and enforced disappearances or threats thereof? Yes. Extralegal killings are killings committed without due process of law, that is, without legal safeguards or judicial proceedings. On the other hand, enforced disappearance has been defined as the arrest, detention, abduction, or any other form of deprivation of liberty by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state, followed by a refusal to acknowledge the deprivation of liberty or by concealment of the fate or whereabouts of the disappeared person, which place such a person outside the protection of the law. Lori Marie Thomas Callo versus Commander Jaime Morente et al., TR 230324, September 19, 2017. Is an ordinance authorizing the immobilization or clamping of illegally parked motor vehicle valid? Yes. The clamping of the tires of illegally parked vehicles was a fair and reasonable way to enforce an ordinance against its transgressors. Otherwise, the transgressors would evade liability by simply driving away. Notice and hearing under such circumstance would be superfluous. Valentino L. Legaspi versus City of Cebu, tier numbers 159, 110, and 159692, December 10, 2013. What does equal protection mean? Equal protection simply requires that all persons or things similarly situated should be treated alike, both as to rights conferred and responsibilities imposed. The equal protection of the laws clause of the Constitution allows classification. A law is not invalid because of simple inequality. All that is required of a valid classification is that it be reasonable, which means that the classification should be based on substantial distinctions, which make for real differences, that is, must be germane to the purpose of the law, that it must not be limited to existing conditions only, and that it must apply equally to each member of the class. Jesus Garcia versus the Honorable Ray Allen Drilon, GR 179267. So on the question whether RA 9262 or the Anti-Violence Against Women and Their Children Act of 2004 as unconstitutional, it is constitutional. RA 9262 does not violate the guarantee of equal protection of the laws because it rests on substantial distinctions. The unequal power relationship between women and men, the fact that women are more likely than men to be victims of violence, and the widespread gender bias and prejudice against women all make for real differences, justifying the classification under the law. RA 9262 is not violative of the Due Process Clause of the Constitution. There is no violation of procedural due process in the ex parte issuance of a temporary protection order. Since time is of the essence in cases of vowsy if further violence is to be prevented, the court is authorized to issue ex parte a TPO after raffle, but before notice and hearing, when the life, limb, or property of the victim is in jeopardy, and there is reasonable ground to believe that the order is necessary to protect the victim from the immediate and imminent danger of violence or to prevent such violence which is about to recur. And third, there is no undue delegation of judicial power to barangay officials. The Barangay Protection Order or BPO issued by the punong barangay or in his unavailability by any available barangay kagawad merely orders the perpetrator to desist from A. Causing physical harm to the woman or her child, and 2. Threatening to cause the woman or her child physical harm. Such function of the punong barangay is thus purely executive in nature, in pursuance of his duty under the local government code to enforce all laws and ordinances and to maintain public order in the barangay. Jesus Garcia versus the Honorable Ray Alan Drilon. And the question whether a search by a government investigating team of a government employee's files that are stored in his or her government assigned computer located in his or her government office, if it is violative of the Constitution, the answer is no. A government employee's expectation of privacy in a regulated office environment is reduced due to the company's work policies, the collective bargaining agreement, if any, and the inherent right of the employer to maintain discipline and efficiency in the workplace. Moreover, a government employee cannot have a subjective expectation of privacy in his government-issued computer containing his personal files. If the government office implements a policy that puts its employees on notice that they have no expectation of privacy in anything they create, store, send, or receive on the office computers. Polo versus Constantino David, TR 181881. When does lack of jurisdiction over the person of an accused as a result of an invalid arrest be raised? Lack of jurisdiction over the person of an accused as a result of an invalid arrest must be raised through a motion to quash before an accused enters his or her plea. Otherwise, the objection is deemed waived and an accused is stopped from questioning the legality of his or her arrest. But failure to timely object to the illegality of an arrest does not preclude an accused from questioning the admissibility of evidence seized. The voluntary submission of an accused to the jurisdiction of the court and his or her active participation during trial cures any defect or irregularity that may have attended an arrest. The reason for this rule is that the legality of an arrest affects only the jurisdiction of the court over the person of the accused. However, the inadmissibility of the evidence is not affected when an accused fails to question the court's jurisdiction over his or her person in a timely manner. Jurisdiction over the person of an accused and the constitutional admissibility of evidence are separate and mutually exclusive consequences of an illegal arrest. Mario Viridiano versus People of the Philippines, GR 200 370, 2017. On the question about having privacy in Facebook posts. To have an expectation of privacy in Facebook posts, a user must show intention to keep certain posts private through the use of privacy tools. Before one can have an expectation of privacy in his or her online social network's activity, it is first necessary that said user manifests the intention to keep certain posts private through the employment of measures to prevent access thereto or to limit its visibility. And this intention can materialize in cyberspace through the utilization of the OSN's privacy tools. In other words, Utilization of these privacy tools is the manifestation in cyber world of the user's invocation of his or her right to informational privacy. A person who places a photograph on the internet, example Facebook post in public, precisely intends to forsake and renounce all privacy rights to such imagery. If such were the case, he or she cannot invoke the protection attached to the right to informational privacy. Availment of the writ of habeas data, therefore, requires the existence of a nexus between the right to privacy, on one hand, and the right to life, liberty, or security, on the other. Vivaris versus St. Teresa's College, GR 202666, 2014. How about the holding of Catholic Masses at the basement of the Quezon City Hall of Justice? Is it a case of establishment or merely accommodation? First, there is no law, ordinance, or circular issued by any duly constituted authorities expressly mandating that judiciary employees attend the Catholic Masses at the basement. Second, when judiciary employees attend the Masses to profess their faith, it is at their own initiative as they are there on their own free will and volition, without any coercion from the judges or administrative officers. Third, no government funds are being spent because the lightnings and air conditioning continue to be operational even if there are no religious rituals there. Fourth, the basement has neither been converted into a Roman Catholic chapel, nor has it been permanently appropriated for the exclusive use of its faithful. Fifth, the allowance of the Masses has not prejudiced other religions. In letter of Tony Valenciano, holding of religious rituals at the Hall of Justice building in Quezon City, March 7, 2017. What are the three tests of judicial scrutiny used to determine the reasonableness of classification? 1. Strict scrutiny test. The strict scrutiny test applies when a classification either 1. Interferes with the exercise of fundamental rights, including the basic liberties guaranteed under the Constitution, and 2. Burdens suspect classes. B. Intermediate scrutiny test. This applies when a classification does not involve suspect classes or fundamental rights, but requires heightened scrutiny, such as in classifications based on gender and legitimacy. C. Rational basis test. This applies to all other subjects not covered by the first two tests. And in the case of Spark versus Quezon City, the court found it proper to examine the assailed regulations under the strict scrutiny test, as the Curfew ordinances set restrictions on the minors' exercise of their right to travel under Section 6, Article 3 of the Constitution. Let's take a quick break and wait for all those noises to subside. And if you're not yet subscribed to our channel, go ahead and hit that subscribe button and let's study together. Thanks. Strict scrutiny test defined. Under the strict scrutiny test, a legislative classification that interferes with the exercise of a fundamental right or operates to the disadvantage of a suspect class is presumed unconstitutional. Thus, the government has the burden of proving that the classification is 1. Necessary to achieve a compelling state interest, and 2. Is the least restrictive means to protect such interest, or the means chosen is narrowly tailored to accomplish the interest. Compelling state interest defined. Children's welfare and the state's mandate to protect and care for them as parents patriae constitute compelling interest to justify regulations by the state. The state has a compelling interest in imposing greater restrictions on minors than on adults. Least restrictive means. The second requirement of the strict scrutiny test stems from the fundamental premise that citizens should not be hampered from pursuing legitimate activities in the exercise of their constitutional rights. While rights may be restricted, the restrictions must be minimal or only to the extent necessary to achieve the purpose or to address the state's compelling interest. When it is possible for governmental regulations to be more narrowly drawn to avoid conflicts with constitutional rights, then they must be so narrowly drawn. Samahan ng mga progresibong kabataan, Sparks versus Quezon City. In Park versus Quezon City, 3 curfew ordinances were assailed to it. 1. Manila. Ordinance number 8046, an ordinance declaring the hours from 10 p.m. to 4 a.m. of the following day as barangay curfew hours for children and youths below 18 years of age, prescribing penalties therefore, and for other purposes. 2. In Navotas, Pambayang Ordinansa bilang 9902, as amended by Pambansang Ordinansa bilang 202-13. Nagtakda ng curfew ng mga kabataan na wala pang 18 taong gulang sa bayan ng Navotas, Calakhang, Maynila. These two were struck down as unconstitutional for failing to pass the second prong of the strict scrutiny test, since they were not narrowly drawn in that their exceptions were inadequate and run the risk of overly restricting the minors' fundamental freedoms. Number 3, in Quezon City, Ordinance Number SP 2301-2014, an ordinance setting for disciplinary hours in Quezon City for minors from 10 p.m. to 5 a.m., providing penalties for parents or guardian for violation thereof and for other purposes. Constitutional. The court has held that the Quezon City Ordinance stands in stark contrast to the first two ordinances, as it sufficiently safeguards the minor's constitutional rights, as its list of exemptions is more narrowly drawn to sufficiently protect the minors' rights of association, free exercise of religion, travel, to peacefully assemble, and of free expression. Does the constitutional right of an accused to confront the witness against him apply in preliminary investigation? No. Preliminary investigation is not a part of trial and is only in a trial where an accused can demand the full exercise of his rights, such as the right to confront and cross-examine his accusers to establish his innocence. Thus, there is no denial of due process in case of denial during preliminary investigation of the respondent's motion to call the witness against the respondent for clarificatory questions. A respondent in a preliminary investigation is not yet an accused person, and hence cannot demand the full exercise of the rights of an accused person, such as the right to confrontation. Estrada versus Office of the Ombudsman, TR 212140, January 21, 2015. Citizenship. Are Foundlings presumed to have the nationality of the country of birth? Yes. Under the 1987 Constitution, generally accepted principles of international law form part of the laws of the land. Generally accepted principles of international law include international custom as evidence of a general practice accepted as law, and general principles of law recognized by civilized nations. International customary rules are accepted as binding as a result from the combination of two elements: the established, widespread, and consistent practice on the part of the states, and a psychological element known as the opinion juris sive necessitates, opinion as to law or necessity. It is a generally accepted principle of international law to presume foundlings as having been born of nationals of the country in which the foundling is found. Paul Lamansares versus Comelec. Are foundlings natural-born citizens? Yes. Foundlings are, as a class, natural-born citizens. While the 1937 Constitution is silent as to foundlings, there is no restrictive language that would exclude them either. Likewise, domestic laws on adoption support the principle that foundlings are Filipinos. Moreover, circumstantial evidence that a person with typical Filipino features is abandoned in Catholic Church in a municipality where the population of the Philippines is overwhelmingly Filipino, such that there would be more than 99% chance that the child born in the province would be a Filipino, would indicate more than ample probability, if not statistical certainty, that petitioner's parents are Filipinos. The same case. Miscellaneous provisions. What are the constitutional requirements for a valid service contract for the large-scale exploration and development of minerals, petroleum, and other mineral oils? 1. The service contract shall be crafted in accordance with the general law that will set standard or uniform terms, conditions, and requirements, presumably to attain a certain uniformity in provisions and avoid the possible insertion of terms disadvantageous to the country. 2. The president shall be the signatory for the government because supposedly, before an agreement is presented to the president for signature, it will have been vetted several times over at different levels to ensure that it conforms to law and can withstand public scrutiny. 3. Within 30 days of the executed agreement, the President shall report it to Congress to give that branch of government an opportunity to look over the agreement and interpose timely objections, if any. Resident marine mammals of the protected seascape of Tenon Strait versus Secretary Reyes, Dear 180771, April 25, 2015. In the case of Knights of Rizal versus DMCI Homes, Assailing Ordinance Number 8119, nowhere in Ordinance Number 8119 or in any law or ordinance or rule for that matter that the construction of a building outside the Rizal Park is prohibited if the building is within the background sight line or view of the Rizal Monument. There is no legal duty on the part of the City of Manila to consider the standards set under Ordinance Number 8119 in relation to the applications of DMCI Homes, PDI, for the Torre de Manila, since under the ordinance, these standards can never be applied outside the boundaries of Rizal Park. While the Rizal Park has been declared a National Historical Site, the area where Torre de Manila is being built is a privately owned property that is not part of the Rizal Park that has been declared as a National Heritage Site in 1995. And the Torre de Manila area is in fact well beyond the Rizal Park. Neither has the area of the Torre de Manila been designated as a heritage zone or cultural property, a historical landmark, or over a national treasure. Does due process in administrative proceeding require the submission of pleadings or a trial type of hearing? No. Due process is satisfied if the party is duly notified of the allegations against him or her and is given a chance to present his or her defense. Furthermore, due process requires that the proffered defenses should have been considered by the tribunal in arriving at its decision. Bangko Sentral ng Pilipinas versus Commission on Audit, TR 213581, September 19, 2017. What is the three-term limit rule under the local government? Cause, assumption of office by operation of law. Example, succession. Effect, considered an interruption. It is not a voluntary renunciation of prior office. The reason? To count as a term, one must have been elected and served. Law allows the severance of effectuate succession. Recall election. Effect, service on the remaining term not counted in the three-term bar. Reason, interrupted by defeat or non-participation in the previous election. Conversion of municipality to city. Effect, no interruption. Reason, no break in service as local chief executive. Preventive suspension. Effect, not considered an interruption. Reason, suspended officer continues to hold the position but only barred from dispensing its functions. Election protest. Effect, if unseated during the same term, interruption. Reason, not deemed elected for the said term. If unseated after the service of the full term, not an interruption. Reason, managed to serve the term from start to finish. The period served by the unseated officer is considered an interruption to the service of the duly proclaimed winner. Reason, the proclaimed winner was deemed a private citizen, warming his heels while awaiting the outcome of his protest. Abunda versus Comelec, 2013. Law and public officers. What is the threefold liability rule? The threefold liability rule holds that the wrongful acts or omissions of a public officer may give rise to civil, criminal, and administrative liability. This simply means that a public officer may be held civilly, criminally, and administratively liable for a wrongful doing. Thus, if such violation or wrongful act results in damages to an individual, the public officer may be held civilly liable to reimburse the injured party. If the law violated attaches a penal sanction, the erring officer may also be punished criminally. Finally, such violation may also lead to suspension, removal from office, or other administrative sanctions. The action that may result for each liability under the threefold liability rule may proceed independently of one another, as in fact, the quantum of evidence required in each case is different. Jose S. Ramiscal Jr. versus Commission on Audit, GR 213716, 2017. Abandonment of the condemnation of doctrine. The concept of public office is a public trust, and the corollary requirement of accountability to the people at all times, as mandated under the 1987 Constitution, is plainly inconsistent with the idea that an elective local official's administrative liability for misconduct committed during a prior term can be wiped off by the fact that he was elected to a second term of office, or even another elective post. Election is not a mode of condoning an administrative offense, and there is simply no constitutional or statutory basis in our jurisdiction to support the notion that an official elected for a different term is fully absolved of any administrative liability arising from an offense done during a prior term. Conchita Carpio Morales versus CA and Jejomar Binay, TR 217 126 227. So, while the doctrine of condemnation has been abandoned, its application should only be prospective. In November 10, 2015, the Supreme Court in Conchita Carpio Morales versus CA and Jejomar Binay extensively discussed the doctrine of condemnation and ruled that such doctrine has no legal authority in this jurisdiction. It should, however, be clarified that the Court's abandonment of the condemnation doctrine should be prospective in application for the reason that judicial decisions applying or interpreting the laws or the Constitution, until reversed, shall form part of the legal system of the Philippines. Hence, the same doctrine is still applicable in cases that transpired prior to the ruling of the Supreme Court in Carpio Morales versus CA. Election law. Is biometrics validation as not a qualification to the exercise of suffrage? RA 10367, entitled An Act Providing for the Mandatory Biometrics Voter Registration, constitutional? Yes. Biometrics validation, or no bio no voto, is not a qualification to the exercise of right of suffrage, but a mere aspect of registration of which the state can reasonably regulate. Qualifications must be distinguished from registration. Registration is only one step towards voting, and not one of the elements that make a citizen a qualified voter. Registration regulates the exercise of the right of suffrage and not a qualification for such right. Kabataan Party List versus Comelec, GR 221318. But Comelec's rule on aggregate-based airtime limits is unconstitutional. First, the Comelec's rule limiting the broadcast and radio advertisements of candidates and political parties for national election positions to an aggregate total of 120 minutes for political campaigns or advertisements unreasonably restricts the freedom of speech and of the press. It unduly restricts and constrains the ability of candidates and political parties to reach out and communicate with the people. Second, the Comelec's rule violates the people's right to suffrage. Fundamental to the idea of a democratic and republican state is the right of the people to determine their own destiny through the choice of leaders they may have in government. Thus, the primordial importance of suffrage and the concomitant right of the people to be adequately informed for the intelligent exercise of such birthright. Lastly, the new resolution introduced a radical change in the manner in which the rules on airtime for political advertisements are to be reckoned. As such, there is a need for adequate and effective means by which they may be adopted, disseminated, and implemented. In this regard, it is not enough that they be published or explained after they have been adopted. Hence, for failing to conduct prior hearing before coming up with the assailed rule, the new rule on aggregate airtime is defective and ineffectual. GMA Network versus Commission on Election, TR 205 357, 2014. Another unconstitutional order of Comelec is the order for removal of two large tarpaulins posted on the front walls of San Sebastian Cathedral of Bacolod. Comelec's order violated the constitutional freedoms of speech and of expression, and of the right to property of the petitioner. First, tarpaulins put up by private individuals that contain statements of their approval or criticism of public officials' vote on the RH law as part of these private individuals' advocacy campaign against the RH law and not paid for by any candidate or political party are not election propaganda subject to Comelec regulation. Second, the prohibition on the posting of non-candidates of tarpaulins containing opinions that may affect elections is a content-based prior restraint that is presumed invalid unless the prohibition passes the clear and present danger test. Here, there is no compelling state interest endangered by the posting of the tarpaulin. Third, regulation of election paraphernalia involving speech of persons who are not candidate is valid if what is regulated is declarative speech that, taken as a whole, has for its principal object the endorsement of a candidate only. The regulation A should be provided by law, B reasonable, C narrowly tailored to meet the objective of enhancing the opportunity of all candidates to be heard, and considering the primacy of guarantee of free expression, and D demonstrably the least restrictive means to achieve that object. The regulation must only be with respect to the time, place, and manner of the rendition of the message. Lastly, the act of the Comelec in restraining private individuals from posting tarpaulins expressing political views in their own private property is an impermissible encroachment on the right to property. The Comelec prohibition is a deprivation of property without due process. The Diocese of Bacolod versus Commission on Election, GR 205728. Substitution of candidates. Is substitution allowed after the last day for filing of COC? An official party candidate dies, withdraws, or is disqualified for any cause? Yes, provided only a person belonging to and certified by the same political party may file a certificate of candidacy to replace such candidate. Is substitution allowed if candidate who dies is an independent candidate? No. Under the case of Recavo versus Comelec, 1999. How about if the certificate of candidacy had been denied due course to and or canceled? Substitution is not allowed. Tagolina versus HRET. Is substitution allowed if candidate lacks qualification and or has made material representation in COC that is false? No. Talaga versus Comelec, 2012. Notes: a disqualified candidate may only be substituted if he had a valid COC in the first place, because if the disqualified candidate did not have a valid and seasonably filed COC, he is and was not a candidate at all. If a person was not a candidate, he cannot be substituted under Section 77. Reason: allowing the so-called substitute to file a new and original COC beyond the period for the filing thereof amounts to unequal protection of the law. Palaga versus Comelec. A misrepresentation in COC is material when it refers to a qualification for elective office and affects the candidate's eligibility. Luz versus Comelec, 2007. Is substitution allowed if a minor filed a COC as official candidate of a party but subsequently withdrew after the deadline of filing of COC? Yes, if candidate, herein the minor, made material misrepresentation as to his date of birth or age in COC, his eligibility may only be impugned through a verified petition to deny due course to or cancel such COC under Section 78 OEC, Luna versus Comelec. The COC of an ineligible must first be cancelled or denied due course by the Comelec to impugn subsequent substitution. Absent such action, substitution is proper. What is extradition? Extradition is the surrender by one nation to another of an individual accused or convicted of an offense outside of its own territory and within the territorial jurisdiction of the other, which, being competent to try and to punish him, demands the surrender. The right of a state to successfully request the extradition of a criminal offender arises from a treaty with the requested state. Absent the treaty, the duty to surrender a person who has sought asylum within its boundaries does not inhere in the state, which, if it is so wishes, can extend to him a refuge and protection, even from the state that he has fled. Government of Hong Kong Special Administrative Region versus Juan Antonio Muñoz, GR 207342, August 16, 2016. What is the principle of complementarity? The principle of complementarity means that the International Criminal Court, ICC, is intended to complement, not replace, national criminal system. It prosecutes cases only when states do not or are unwilling or unable to do so genuinely. Under Article 17 of the Rome Statute, a case is inadmissible if 1. The case is being investigated or prosecuted by a state which has jurisdiction over it, unless the state is unwilling or unable genuinely to carry out the investigation or prosecution. 2. The case has been investigated by a state which has jurisdiction over it, and the state has decided not to prosecute the person concerned, unless the decision resulted from the unwillingness or inability of the state genuinely to prosecute. Or C. The person concerned has already been tried for conduct which is the subject of the complaint. What is the jurisdiction of the International Criminal Court and the International Court of Justice? 1. ICC. Jurisdiction may be exercised over persons. International Court of Justice. Only states may be a party to the case. 2. Jurisdiction deals with genocide, crimes against humanity, war crimes, and aggression. Article 5 of Rome Statute. Jurisdiction deals with contentious cases between states concerning 1. The interpretation of a treaty. 2. Any question of international law. 3. Existence of any fact which, if established, constitutes a breach of an international obligation. And 4. Nature or extent of reparation for a breach of international obligation. Article 36 of ICJ Statute. What is the precautionary principle? When there is a lack of full scientific certainty in establishing causal link between human activity and environmental effect, the court shall apply the precautionary principle in resolving an environmental case before it. The principle is restored to prevent irreversible harms or prejudice against the environment and or future generations. International Service for the Acquisition of Agri-Biotech Applications versus Greenpeace Southern Asia Philippines, GR 209276, December 8, 2015. Nonetheless, scientific analysis is still a necessary basis for effective policy choices under the precautionary principle. Although the rule allows lack of full scientific certainty in establishing a connection between the serious or irreversible harm and a human activity, its application must still be based on empirical studies. Any ordinance which applies the principle arbitrarily must be struck down. Wilfredo Mosqueda et al. Versus Filipino Banana Grower and Exporters Association, GR numbers 189185 and 189305, August 16, 2016.